Welcome to the Loud Little Ducky. This is going to be part 5 in the timeline of Owens v. Echard. This is going to catch us up to present day. And so if we need more parts, we'll add those on. I know the trial is supposed to be in June, so we may have some updates then. But in this one, we are ending with several motions, police call, going over a hearing, and a deposition transcript. So that will all be interesting. So let's jump right into today. This is just a little piece of kind of housekeeping that goes with the Emily Wilson thing from the last video. It was a motion to withdraw the name change because remember she was trying to change her name. And it says, Your Honor, I, Laura Owens, the petitioner in this case of blah, hereby submit this motion to respectfully request the withdrawal of my name change petition filed on November 7, 2023. Furthermore, I seek a refund of any associated fees due to the circumstances outlined below. On November 7, 2023, I submitted a petition to change my name due to personal reasons. Regrettably, a YouTube content creator named Dave Neal discovered my name change petition shortly after its filing and chose to share this information with his audience. This dissemination of my intended name change, as well as the reason why I requested it, have rendered the new name ineffective and therefore unusable due to the public exposure. Oh my God, you've been outed because you were using it to hide from consequences. You weren't using it because you were in danger of anything. You weren't being anything. Like, you are using it to hide behind things. So, good. I'm glad you don't have a name change because everybody needs to know who you are and what you are about. February 2nd, Clayton shows up for his deposition. Owens attends it as well. Isn't that funny? Because she can't even be bothered to go to her own deposition. But by gosh, she's going to be there for Clayton. You know, I'm going to make sure he doesn't tell any lies. So I can say, oh, this is all lies. So you're not really concerned for your safety if you're willing to show up for his deposition, but not your own, where Clayton probably would not have been. I don't think Clayton would have gone to your deposition because he don't want to be around you. And February 6th, Clayton's lawyer files expedited motion to continue trial and motion for additional trial time. And here we have that motion. So this was filed on 2/6, as we said, and it is assigned to Judge Matta, and it's got Owens v. Echard. It says, Respondent Clayton Echard by and through counsel undersigned and pursuant to Rule 34, Arizona Rules of Family Law and Procedure, hereby request that this court continue the evidentiary hearing on sanctions and attorney's fees currently set for February 27, 2024 at 4 p.m. Respondent also requests that this court allow additional 75 minutes for this hearing for a total of 2 hours. This motion is expedited as trial is currently scheduled for the end of February and petitioner has failed to provide any disclosure, see below, and has engaged in what appears to be a concerted effort to undermine the judicial process. If that's not the understatement of the year. Continuing on, as repeatedly stated in respondent's prior filings, petitioner has wantonly and willfully failed to provide any Rule 49 disclosure, respond to any requests for production, and refuse to attend a properly noticed Rule 57 deposition. Petitioner has further refused to sign fetal death certificate or a basic HIPAA release related to any form of medical care she testified to receiving for her alleged, air quote, high-risk pregnancy. Notwithstanding this conduct, respondent appeared at petitioner's noticed video deposition at her most recent counsel's office and fully participated last Friday on February 2nd. The issue of sanctions and attorney's fees cannot be adequately adjudicated without disclosure and discovery from petitioner, including the opportunity for respondent to depose petitioner. Again, petitioner video deposed respondent on February 2nd, 2024, after initially failing to appear at her own properly noticed deposition. Additionally, the 45 minutes currently allocated for this hearing will not allow respondent to fully present his position on the issues. As and for this motion to continue trial, respondent states, on August 1st, 2023, petitioner Owens initiated the underlying action when she filed her petition to establish paternity, legal decision-making, parenting time, and child support, alleging she was pregnant with respondent's twins after one night of oral. Number 2, respondent maintains that this alleged pregnancy was a hoax/con, much like the previous litigated matters involving petitioner and other men similarly situated. Here, as with the prior matter, petitioner faked medical records as her supposed proof of pregnancy. This time, petitioner chose a television personality on which to perpetrate this fraud, and not only faked the pregnancy, but attempted to extort him to date her in exchange for an abortion of fictional twins. You can't abort something that doesn't exist. Respondent refused to date petitioner, who then continued to promote the false narrative that she was pregnant to the media and the court system, including during the subsequent injunction against harassment proceeding, where she appeared on video in court wearing an ostensibly fake pregnant stomach, and asked the judge in that hearing to allow her to show respondent that she was pregnant. She then continued to contact the media, including the tabloid, The Sun, Reddit, Medium.com, podcasters Dave Neal, and Reality Steve, and etc., furthering her entire fraudulent fake pregnancy narrative. On August 21st, 2023, respondent filed his answer denying that the petitioner could scientifically be pregnant with his twins after they engaged only in oral on May 20th, 2023. Petitioner seems to acknowledge that no sex occurred in her bevy of 500 emails and texts, which resulted in Judge G granting an injunction against harassment against petitioner after a 2-day trial on the same. Number 5, nearly 7 months have passed since petitioner initiated this action, during which no disclosure has been provided by the petitioner, despite the requests made to her numerous counsels in accordance with Rule 49. Number 6, petitioner has willfully and wantonly failed to comply with Rule 49. Rule 49 provides in pertinent part as follows: unless the parties agree in writing or the court. The footnote is respondent. The footnote for this TV personality says previously appeared on the ABC's The Bachelorette and was the star of The Bachelor. But unless the parties put in writing written orders, otherwise every party must serve an initial disclosure of information required under sections D through K no later than 40 days after the filing of the first responsive pleading to a petition. Emphasis added. As respondent filed this response on August 21st, 2023, petitioner's Rule 49 disclosure was due not later than September 30th, 2023. As of filing, no disclosure has been provided. Respondent intends on filing a motion to compel in short order. Number 7. On January 17, 2023, the petitioner failed to appear at a properly noticed deposition. See respondent's notice of non-appearance at a deposition pursuant to Rule 57. Notably, respondent appeared and cooperated with petitioner's video deposition on February 2nd, 2024. Respondent, number 8, Respondent is unable to fully and meaningfully present his argument, for which he should be awarded attorney's fees and sanctions, and a finding that the petition was filed in bad faith against the petitioner. Without disclosure from petitioner. She seems to know that after the myriad of conversations had with the petitioner's attorneys, and is flaunting her failure to provide the same. Petitioner's convenient claim, an effort to get the case dismissed without full adjudication by now saying she is no longer pregnant, does not indemnify her from providing Rule 49 disclosure or participating in discovery in accordance with the rules as fully detailed in respondent's response/objection to petitioner's motion for confidentiality and preliminary protective order. That is a long name. These things have long names. To date, petitioner has provided no verifiable proof of pregnancy by respondent. The foundational basis of her original petition to establish, and despite her invocation of Rule 2, and a footnote says petitioner's counsel did offer to provide only limited disclosure at respondent's deposition, but not in a manner that would satisfy the evidentiary standards of Rule 2, which petitioner invoked, and respondent is unwilling to accept any disclosure that is not provided from the source itself, due to petitioner's history of arts and crafts of medical evidence, including fake sonograms. A footnote about arts and crafts. As a crafter myself, this offends me. I don't be doing this kind of arts and crafts. I do other kinds of arts and crafts. Moving on. If she did have a miscarriage, seemingly impossible as she could not have been pregnant from oral, it does not explain her under oath testimony with Judge G, where she displays her pregnant stomach and confirms in her testimony that she is not only pregnant, 24 weeks at the date of the testimony, but under the care of multiple medical providers for her high-risk condition. Yes, because she always has to throw that in, because it's the worst of the worst, so she needs extra attention. Simply said, petitioner's pregnancy was faked. The bump displayed in Judge G's courtroom was ostensibly purchased as evidenced by petitioner clearly adjusting what appears to be a fake belly and guzzling Monster energy drink, curious for someone claiming to have a high-risk pregnancy. Her entire petition was predicated on either lies or delusions and mirrors prior litigation involving Miss Owens and a growing list of other victims, at least 3 men that are known, that is including the respondent. Number 9. Respondent has complied with all requests for disclosure and participated in a video deposition as required by the rules and requested by petitioner. Petitioner has provided none and continues to flout the rules of the court she invoked. Yeah, you can't just file a thing and then be like, I'm going to have no proof. But can I win, Your Honor? No, you may not. Denied. Number 10. There is good cause for a continuance given the wholesale lack of disclosure and discovery by petitioner, as no disclosure has been received in relation to any claims made by petitioner, including the original claim of paternity on which this underlying matter was filed. Respondent has been left with an incomplete picture of the full extent to which petitioner's baseless accusations and myriad of filings have harmed him. As such, respondent requests that the hearing be continued to allow for disclosure to be received. Yes. Hand over your discovery. Prove that you were pregnant at one point by anybody. At this point in time, just prove once you were pregnant in your life, because I'm not buying it. Number 11, respondent has been patiently waiting for the petitioner to provide any disclosure for over 7 months. The original claim on which this petition was filed was brought in bad faith over 7 months ago, and no disclosure which to verify it has been proven. Like, the fact that she's been able to drag this nonsense out and they haven't said, you need to produce this, and if you don't, there's going to be consequences. But she's not being held accountable. And I don't know that she ever will, sadly, aside from being called out. Which is why it's important to call people out like this. I mean, this girl deserves to be in jail. And, like, this is a crime. Like, you've got fraud, deception on the court. You've got frivolous filings. There's several crimes being committed in this. And it's not the first time she's done it. She's done these crimes multiple times. But nothing happens. That's why she keeps doing it. Since the petitioner has involved several attorneys and respondent has engaged in significant efforts to facilitate disclosure and discovery, but to no avail. As such, a continuance at this stage is appropriate, and respondent has made diligent efforts to avoid having to file a motion to continue, including several discussions with petitioner's attorneys. Number 12, neither party will be prejudiced by the continuance, which is a good note. You don't want either side to be prejudiced. 13, the continuance is sought in good faith and not for delay, as the respondent needs to access to critical disclosure in order to properly litigate. Yes, we would not need a continuance if she would have come to her deposition, if she would have handed over discovery 12 million attorneys ago. But no, still hadn't handed over anything. As for this motion for additional trial time, respondent states as follows. 14. The evidentiary hearing before the court, currently scheduled for February 27th, is set for 45 minutes. This allows each party less than 25 minutes each to present their arguments for the issues of sanctions and attorney's fees. 15. As this case has been ongoing since August 2023, the issues for the hearing include but are not limited to petitioner's bad faith in bringing underlying paternity action despite not being pregnant by respondent, as was impossible from oral. Therefore, respondent respectfully requests that this court allows the parties an additional 75 minutes of trial time for a total of 2 hours. 16. Undersigned reached out to petitioner's counsel regarding their position on the above, but no response was received. See Exhibit 1. In light of the quickly approaching deadlines, expedited ruling is requested. Wherefore, respondent respectfully requests the court A. Vacate the evidentiary hearing scheduled for February 27th. B. Reset the evidentiary hearing for 60 days to allow time for petitioner to engage in discovery and disclosure. C. Set the evidentiary hearing for at least 2 hours. D. Order such further relief as the court deems just. Respectfully submitted, Greg Woodnick Law. And of course it was copied to the people, sent to the court and the correct parties. This is just the verification of that particular motion that Echard declared under penalty of perjury, that everything is best and true to his knowledge in the document. But on February 5th, so the day before that filing that we just read, Woodnick wrote, Corey, it was nice seeing you on Friday. Since we have not received any disclosure from Laura, the RFPs remain outstanding. The HIPAAs have not been executed. You were provided 3 times. The field death certificates provided 2 times. so ostensibly not executed, and we still need to depose Laura after she failed to appear at her deposition. We are going to file a motion to continue and request additional trial time. I assume you agree, but let me know so I can note it in the motion to continue. Greg with 2 G's. So this was his exhibit showing that he did reach out for comment, but he hadn't heard back. So he just was showing that he did try to contact them about this issue. February 7th, Laura Owens receives harassing Facebook posts from what appears to be a troll account. She calls the police about these Facebook posts. So let's listen. Let's actually go over this first. And so this is the police report. Shows 2/7 at 8:06 p.m. the Scottsdale Police Department. And it has them receiving the threats online that someone is going to come over to her house and her mom's house to shoot them. No one is there now. Search was completed. Rang for 1 minute, then line went silent without a person picking up or going to voicemail. We'll try again in 5 minutes. Tried again, rang for 1 minute, then went silent again, unable to leave voicemail, and then the event is closed. So she's not answering her telephone, and it's going to voicemail. And we know from the last video that was an issue as well, that the voicemail was full, so they can't leave them. So I don't know why she has so many voicemails. She needs to check her voicemails. Stop calling herself and leaving voicemails. But if you are harassed on the internet, report to the FBI, because internet threats of death are a federal crime. If you are the victim of online or internet enabled crime, file a report with the Internet Crime Complaint Center, IC3, as soon as possible. Crime reports are used for investigative and intelligence purposes, and you can go to ic3.gov, which I will have in the description box. And to date, there is no records that Owen has reported this to the FBI cybercrime. Thank you, Nothing But Tea, for this info there. Now let's listen to the call.
Hi, I'm calling because I have somebody who's threatening me and my mom, saying they're going to come shoot us.
Okay, what's your address?
My address, well, I can give my address, but they're actually giving the wrong address for my mom, and they're acting like that's where they're going to go.
Are they threatening you or threatening your mom?
They're saying me, but then they're sending an address for my mom, but it's not actually the right address.
They posted it online.
You're the
Yeah,
one
they posted it on
the threat, is that correct?
And her mom's on the
Correct.
line.
Okay, so what's your address? Okay, and your name?
Redacted.
And your phone number? Okay, and no one's there now that you're aware of?
Not that I'm aware of, no.
Okay. All right. I have a call in to have an officer make contact with you in reference to what they're threatening to make a report. So if you get any blocked or unknown numbers, it might be the officer just reaching out to you. And if for some reason someone does show up in the meantime, just call 911.
And how many times have they
Okay,
told
sounds
her
good. Thank you so much.
You're welcome.
to answer
Bye.
restricted and blocked or private numbers? They've told her a million times. She's done this song and dance so many times. She knows to answer her phone, and she doesn't. February 7th, Owens drops the harassment lawsuit with Neil. Yay! February 11th, the account Justice for Clayton has been banned from Twitter X. February 12th, Clayton's lawyer files expedited motion to set virtual status conference. February 14th, on Owen's alleged due date, Valentine's Day, hearts to everybody, she posts a blog post about miscarriage that is so cruel, insensitive, heartless, immature and irresponsible that we will not link it here. Yeah. Because she wants to play victim. And as said in a previous video, that damn you, Owens, for trying to act like you've been through something you have not. You are stealing something that is so personal to many people, including myself. And to try to act like you've been in our shoes is disgusting. And it just continues to show what kind of disgusting piece of garbage you actually are. And you need serious help to figure out what is wrong with you. Is it your narcissism? Is it delusion? What is it? Because it's despicable. On February 15th, status conference is set for February 21st. The account Justice for Clayton has been reinstated on Twitter. And then February 16th, judge denied Owens' motion to quash her deposition, which means you're gonna go to the deposition. You're not getting out of the deposition just because you wanna. We're too far down the line for that to be happening. The next few days, the Justice for Clayton sub on Reddit was banned and reinstated twice. I want to think the wiki page did too. She's out there trying to ban all of this truth because it doesn't fit her narrative. This is an order entered by the court on 2/15. I know it's blurry, but it says the court has received and considered petitioner's motion for confidentiality and preliminary protective order filed on January 17th, 2024, respondent's response/objection filed on January 19th, and the petitioner's reply filed on January 31st. It is ordered denying petitioner's motion for confidentiality and preliminary protective order filed on January 17th, 2024. All parties representing themselves must keep the court updated with address changes. A form may be downloaded at the Maricopa County Superior Court website. So, denied, and that was by Judge Matta. Here is a picture of what the hearing looked like on February 21st. We've got the judge. I guess this would be the witness stand, maybe. And then down in the bottom left, we have Corey Keith sitting next to Owens. Then on the lower right, we have Clayton with Woodnick. My guess is Isabella is sitting right behind him. And then in the black shirt back here, I believe this is actually Greg Gillespie, which she is pissed about. Owens is not happy that he is there. But oh well. Stop screwing men over. Literally. Actually, nobody's screwing you, so it's not literally. Nobody wants you. So, at the February 21st status conference that was held, Owens and Echard were present along with their lawyers, as we just showed. The judge denied the motion to seal and dismiss. Judge did approve extended time of hearing, and Owens needs to be deposed. Judge set deposition to be on March 1st. June 10th is the new hearing date. Owens claims in this hearing that she thought she was pregnant in November, but found out later that she had a miscarriage 1 to 2 months prior. So you don't know if it's 1 or 2 months prior. So you don't know if it was October or September. And let's see, June, July, August, September, you would still be at 20 weeks. But okay. And you had just seen the doctor prior. Like, you just saw them before that hearing on the 2nd. And you were 100% sure that you were pregnant then. And you had gone to your doctor. And you're telling me that they didn't check a heartbeat? They didn't do an ultrasound? Like, you just went there. There is no way that at that doctor's appointment you would not have known it. It would have been known. Because there would have been no heartbeat, which they check at every single doctor's appointment. So, your lies don't make sense. And then, so, this hearing on the 21st contradicted her claims from the 2nd. They make no sense. And then Reality Steve also claims that in a correspondence with her, she was claiming she was still pregnant in December. So when Reality Steve talked to her in December, she was stating she was still pregnant. And so, like, you need to get your story straight. Maybe you should have written it down in a journal or logged it on your Medium posts. Because your memory is crappy, but it's hard to remember lies. February 22nd, it was discovered that Owens' December 8th post on Medium had been edited from what she posted initially. On her original post, December 7th, she initially included, "However, I won't be sharing updates regarding the status of my pregnancy with Clayton. I kindly ask not to receive congratulations or engage in discussions about Clayton and my pregnancy." And it says, this post is not intended for that purpose. She has since removed that portion of the post. Yeah, because there is no discussions about you and Clayton in your pregnancy. Because there's no you and Clayton. And there's no you, Clayton, and babies. There is no pregnancy. There is nothing. And nobody's congratulating you. Nobody. Maybe your parents. Maybe your sister. She seems to be enabling you and by your side too. But they all are being made out to be fools because nobody will call her out on her BS. Get it together. February 27th, Owens emails Clayton's attorney, Greg Woodnick, directly. She did not have her lawyer contact Woodnick, which is what you're paying your attorney to do, so that you don't have contact with the other side directly. You're not pro se at this point on this part of the case. Use your attorney. This may be part of the reason that Corey Keith left, because you're doing things without his permission, and you're going rogue. Stating that she intends to sue Echard for $1.4 million for breaches of contractual and fiduciary duties as well as emotional distress. You are the only one causing emotional distress in your life. You are the problem. It is you. She states in this email that she will not sue Clayton if he drops the family court case against her, and that he has until the day before her deposition to agree to her terms. That's blackmail. That's extortion. You can't be doing that. That's not legal. Woodnick also mentions in his email that 3 of the doctors that Owens has claimed to have seen for her pregnancy have responded to the HIPAA request, stating that they have no patient by the name of Laura Owens. These places have not seen her. So that begs the question of whose pictures did she steal? And she was doing lots of arts and crafts. Maybe that's why she can't answer the phone anytime the police call. March 1st, Owens finally attends her deposition. Thank the heavens for this. And I hope one day we get to actually see the video of this and the whole deposition transcript. March 7th, Echard releases a statement to the press stating that Owens, during her deposition on March 1st, admitted to tampering with the ultrasounds from Southwest Medical Imaging. So she admitted to her arts and crafts. Admitted to fraud. That is a crime that needs criminal charges. Okay. Here on March 11th, 2024, we have the motion to compel, and this is going to go to Judge Matta in Owens v. Echard. And this is long and it's got several exhibits, so just bear with me so we can get all the juicy gossip. It says, Respondent Echard, by and through counsel undersigned pursuant to Rule 65A2, Arizona Rules of Family Law and Procedure, hereby moves this court to compel petitioner's disclosure and enter appropriate sanctions for her non-compliance. At petitioner's Rule 57 deposition on March 1st, 2024, petitioner testified, 1. She altered an ultrasound image falsely claiming they came from Southwest Medical Imaging, which was SMIL or SMIL. And the footnote is, to be clear, this motion to compel in no way implies that the petitioner's multiple prior attorneys on her current counsel knew that they were using falsified and tampered medical evidence. No, because she's not going to disclose that to them. They're going to have to figure that out themselves. And once they figure it out, they leave and withdraw the case. Number 2, she quote unquote miscarried two hand-sized fetuses sometime in September or October, and was not seen by yet to be named telehealth providers, but provided no records regarding the same nor confirmation of the alleged event. I don't know that they're doing telehealth OB appointments. Maybe if anybody knows of people that are doing OB appointments telehealth wise, let me know, because I don't think that they would be, because they either need to see the baby, make sure the baby is okay with hearing the heartbeat, and a telehealth is not going to be able to do that. So that's a lie. And if she's saying that telehealth is why she didn't know, it's just more lies. That's all this woman does anyways. 3, when she miscarried, she took photos of what would have been of a 19 to 24 week twin fetuses, but she no longer has the photos, which she claimed she sent to her sister because she had gotten a new phone. And 4, there's a 4th case in California where someone alleged the petitioner fabricated a pregnancy. So we have another case. Lovely. And they would have been 19 to 24 weeks. How do you not know? How do you not know how far along they are when you miscarried? And you're saying, okay, so she was saying it was sometime in September, October. She doesn't remember. I'm sorry, but you remember those dates. Those dates are forever embedded into your head when these events happen. You know that on this day is when you miscarried or lost your babies or had to sign a death certificate. You know these dates. It's not just a oops. And you got a new phone. Like, what happened to your old phone? Did you destroy it so that there couldn't be any evidence looked at on that phone? Because if you still have the old phone, you would still have those things. Or you can like email them or message them to yourself or something, but you send them to your sister. Okay, so do we need to depose your sister now? Do we need to seize her phone and texts? And you just got rid of the photos you took of your kids. Because I have pictures of my deceased daughter. I have a shadow box for her. I still have the photos of when I gave birth to her, when she wasn't alive. You don't throw those out, because those are your children still. They're gross photos. They're not the best photos. They don't look like regular human beings. But they're your kids. So, no. Like, she not think that any woman that has ever been through this stuff they'll know and be able to call her out on this stuff. Like, how she thinks she was gonna get away with this? Because she has in the past. Judges have just been like, oh, you sweet angel. These horrible men. No. Stop believing all women. Continuing on with the motion. I'm sorry, I went on a rant. Compulsively lying is not a defense to disclosure of production. Petitioners increasingly apocryphal tales include her telling U.S. Weekly just last week that her pregnancy was confirmed at an urgent care. Again, I'm glad he says it because I would say it. HCG tests are not confirmation of pregnancy. They're not. It just means you could be pregnant. There's a possibility of it. While the loss of a pregnancy is a tragedy, the loss of a fake pregnancy is not. Yeah, nobody feels bad for you. And you have been through no tragedies. Your life is a tragedy, but that's because you made yourself pathetic. Here, a petitioner was photoshopped competing in a horse competition, jumping competitions with a flat stomach weeks before she appeared in court before Judge G. With the seemingly large pregnancy stomach, Moonbelly, claiming she was 100% and 24 weeks pregnant by Clayton, who she never had intercourse with. I said photoshopped. I'm sorry. She was photographed competing in the horse jumping competitions with a flat stomach, which we knew she was competing in these competitions every month in her pregnancy at least. Notably, of litany, 14 plus providers' names given through petitioner's testimony prior to her deposition, multiple providers have denied providing care or ever seeing/communicating with the petitioner. See Exhibit 1, which we will look at. Moreover, petitioner lied about obtaining obstetric care because sonograms taken by actual sonographers cannot be easily faked, nor can a fetal anatomy scan or the frequent checkup appointments one would expect to have for her proclaimed high risk, air quotes, twin pregnancy. Undersigned counsel has sent petitioner's current counsel reminders that this data needs to be immediately disclosed per Rule 49, which petitioner evaded for 8 months now. Counsel has not only received no response, but no response to efforts to meet and discuss consistent with Rule 9C. Regardless, Rule 9C has been complied with. As and for this motion to compel, respondent states as follows. Number 1, and this is just going to bring us through the case. On August 1st, 2023, petitioner initiated the underlying action when she filed her petition to establish paternity, legal decision-making, parenting time, child support, and alleges that she's pregnant with twins. Number 2, on August 21st, respondent filed his answer, so Clayton, denying that the petitioner could scientifically be pregnant with his twins after they only engaged in oral on the 20th of May. Is May 20th now and forever just going to be oral day? Like, is that, because that date is forever embedded into my brain now. So y'all need to be celebrating on May 20th. Number 3. On September 28, 2023, the parties attended an early resolution conference and entered into a Rule 69 agreement stating, petitioner agrees to contribute a sample on October 2, 2023 to determine paternity of alleged pregnancy. Number 4. October 6, 2023, petitioner filed an order of protection against the respondent granted by Judge Duty, alleging that she was pregnant by him and that he was cyberbullying her. Wrong. Number 5. On October 18, 2023, petitioner filed a request for a pre-decree medication, alleging respondent would not speak to her and he even acts as if the onboard children don't exist despite a preponderance of evidence. Okay. Denied November 22nd, 2023. We're still waiting for a preponderance of the evidence, but okay. On the 24th of October, petitioner appeared on video in court proceeding before Judge G wearing what appeared to be a fake stomach / moon belly. Number 7, on November 2nd, in the second day of trial on respondent's granted injunction against harassment against the petitioner. So Echard's granted injunction against harassment against Owens, because she's cray-cray. She testified under oath that she was 100% and 24 weeks pregnant by respondent, and that she was due February 14th, 2024, V-Day. Petitioner further testified that she was having a high-risk pregnancy due to her alleged epilepsy. See, her epilepsy is alleged now too. Because we can't believe this woman. Like, she probably just does it for sympathy. And if she does have it, well, that sucks because nobody believes her with anything she says. And that she was being seen by Dr. McCool, Dr. Higley, and that she had an appointment with Dr. Higley last Friday. So, that was that October thing, and Dr. Higley apparently did not let her know that she had miscarried. This appointment she would have known. But she's saying she didn't know, and she thought she was still pregnant at this point. No. Your doctor would have told you you weren't. Number 8. Petitioner willfully and wantonly refused to comply with any disclosure or discovery rules, forcing respondent to file the following. A. Notice of non-appearance for deposition pursuant to Rules 57. B. Response/objection to petitioner's motion for confidentiality and preliminary protective order. C. Reply to petitioner's response for motion for sanctions pursuant to Rule 26, and D. Amended response to petition to establish paternity. All those legal filings are word salad. There's just a lot of words. Number 9. It was not until the status conference before the court on February 21st, 2024 that the petitioner agreed to sign a basic HIPAA release to allow respondent to obtain the documents himself and in compliance with Rules 2, which petitioner invoked. I don't think she agreed to it. I think the judge told her, you're going to sign this. You don't really have a choice. Like, you wanted to bring these claims. Now you need to prove yourself. Of note, petitioner apparently mistakenly signed the HIPAA release in open court with the wrong year, causing numerous providers to reject the HIPAA release as expired, which they went over that in the hearing, that they were going to need to do it, and that the judge was like, oh, if I just like initial it or whatever. They had talked about this, like that it was messed up. And whether she did that on purpose or not, it still caused a lot of stuff, and they foreshadowed this HIPAA stuff being rejected. Number 10. Since the status conference, respondent has received confirmation from nearly all providers that petitioner was never a patient of theirs. Notably, the HIPAA releases for Dr. McCool revealed that petitioner had never attended an appointment at this office, despite her testimony before Judge G and the appointment confirmation email she submitted as evidence in the injunction matter. Blech. So, as we pointed out, that in this hearing, when we went over the October 2nd hearing, the Clayton's attorney at that point had stated, all we have is a positive HCG test and a picture of an appointment that was made. And that was her medical evidence. And as we said, that just because you make an appointment doesn't mean you actually went to the appointment. And what do you know? As it turns out, that wasn't medical evidence. It was a lie. But we all knew that. Number 11. Days prior to petitioner's deposition, petitioner sent respondent's counsel a letter excluding her own attorney, blatantly seeking to extort respondent into dismissing this action, or she would file a baseless, incoherent, and legally unsupported lawsuit for $1.4 million. See Exhibit 2. If respondent agreed to sign a stipulation to dismiss this action and to mutually agree for forbearing from any future legal actions, no. Don't ever sign something that says you will never sue anybody for anything ever again. Like, no. Because chances are you're gonna need to sue them in the future for something. And that he needed to sign this agreement by February 29th, 2024, which is the day before her deposition, and she would not pursue the fake legal claim, as she has done so already. Number 12. More bizarrely, at the deposition of petitioner on March 1st, 2024, these are things that the petitioner confirmed, as if things could get more bizarre. A. She had never received obstetric care for her high-risk pregnancy with twins, and denied being the owner of the sonograms petitioner posted on Reddit and or provided to various journalists at the beginning of this case. Which we kind of knew that because she blamed that on Greg Gillespie. Ugh, Greg. I have an order of protection against him and he's hacking me. No, he's not. B. She doctored a sonogram to attribute it to Southwest Medical Imaging, Smile, and added her name and date of birth, which was previously an exhibit in a court proceeding. She did this, according to her testimony, because she had initially gotten the sonogram anonymously at Planned Parenthood Mission Viejo Health Center in California, and she did not want respondent to know where she had gone for the sonogram. But somehow she was fine with him thinking that she had gotten it at Smile, Southwest Medical Imaging. And I think somebody actually said, I heard yesterday, I believe, that the Mission Viejo Health Center in California doesn't actually do sonograms, but I could be wrong on that. I haven't looked into that, but I think somebody said that. And so, unsurprisingly, Planned Parenthood Mission Viejo has confirmed that they do not offer anonymous appointments, and they have an easily accessible patient portal. Yeah. Like, you have to tell them who you are. Now, your information does not have to go out to other people, but for like billing purposes, if they're going to bill you and things like that, they have to know who you are. You can stay anonymous to the outside world and nobody has to know about you being there, but you have to give your name. No records from Planned Parenthood Mission Viejo have been disclosed despite the repeated requests, so she's just the anonymous woman. C. According to petitioner, the only individual who told her that she was having boy and girl twins was a medical provider to whom she texted a 6-week, admittedly altered sonogram. Despite medical science and medical experts stating that a sonogram can only determine the sex of fetuses with accuracy around 18 weeks. Petitioner testified that an unnamed provider was able to glean from a 6-week tampered with sonogram that petitioner was pregnant with a boy and a girl. Okay, so I don't think I realized until this point that she found out that they were boy-girl twins at 6 weeks. Like, I knew with the sonogram there was like an A and a B in her fake sonogram that we showed in video 1. But I didn't know at that point she was saying that she had a boy and a girl. And at 6 weeks, you're lucky if they can even do an over-the-belly sonogram. Because sometimes they have to do the internal one, which somebody compared that to a super tampon one time. I was like, you are out of your mind. That is not a super tampon. Oh my God. That's one of the biggest lies I think I've ever been told. Yeah, 6 weeks, it's just this little tiny, like, seed, pumpkin seed, bean, whatever you want to call it. Like, you can't tell. It doesn't have limbs or anything at that point. Like, it definitely doesn't have appendages or no appendages. Jeez Louise, God, this is how you know she's never been pregnant. And I start to question if she's ever even been around anybody that's been pregnant, because this is common sense. I think a lot of people that have never been pregnant before also know that's not accurate, but okay. Like, oh my God. This alleged provider has yet to be disclosed, nor has the text exchange between petitioner and the provider ostensibly, boy, he loves that word, ostensibly, because it does not exist. At the deposition, petitioner claimed she had a new phone and was unable to pull up records to confirm her increasingly ridiculous tale. Her nose is just going to keep growing. She's going to be Pinocchio. Or maybe she'll grow a tail. D. On the undisclosed day of the alleged miscarriage, ambiguous sometime in either September or October, we don't know, and prior to appearing in court before Judge G with a fake pregnant stomach and testifying to being 100% pregnant, petitioner claims to have passed 2 fetal sacs. Of course, she did not go to the hospital or to the doctor. She claims to have met with a telehealth appointment with a provider who she testified was not concerned that she had miscarried. Are you effing kidding me? They would tell you to go to the emergency room or go to labor and delivery right now. Call 911 or have somebody take you there. And if this is whatever, I don't think there was an actual telehealth appointment, but if there was, like, don't ever use, we need to know who that provider is, because we need not to ever use them if they think this is how appointments work. Like, no. Not at this far along. Oh my God. Especially if they knew she was high risk. Incredibly, she testified that she had also shown the 2 hand-sized sacs to her mother and took a photo which she shared with the telehealth provider and her sister. No records have been provided despite the repeated request. So her mother and her sister have now been brought in it. So now we need to depose them. Because you're bringing them into your life. And maybe if your mother and sister have to be brought into this, maybe that'll be the wake-up call to them to get you some help and to quit enabling you. This is just maddening. There's a 4th man who was accused petitioner of fabricating a pregnancy, which supports respondent's contention that faking pregnancy is either a pathological or the oddest of pastimes. Petitioner initiated a paternity action out of California in 2014. See Exhibit 3, regarding what is believed to be our first out of 5 feigned pregnancies. Petitioner was asked to comply with her disclosure of the same. See Exhibit 4. So we were thinking it went back to 2016. Now we know that it goes back to 2014. So we are at over, let's see, 14, 10 years of faking pregnancies. Oh my God. Like, this is seriously a mental illness. And she doesn't ever need to become pregnant, because I have a weird feeling that if she ever did become pregnant and she had babies, she would be one that would be Munchausen's by proxy. I think she would purposely make her kids sick in order for attention. And if she ever does, I hope that the father of the babies, if she ever does, hope she doesn't. She's not somebody that needs to be a mother. I hope the father gets full custody, because this woman does not need to be raising children. Number 13. Petitioner was willfully and wantonly failed to disclose information pursuant to Rule 49 after the status conference before this court. Petitioner provided minimal disclosure after evading any compliance with Rule 49 for over 8 months. Now petitioner has testified to attending appointments and speaking with providers who only have access to records that are critical to support the miscarriage she allegedly had in September or October, but did not reveal to respondent or the court until her motion for confidentiality and preliminary protective order filed on January 17, 2024. Number 14. Respondent has complied with Rule 9C to the extent possible given petitioner's refusal to respond or communicate. See Exhibit 5. As detailed in correspondence, there have been multiple meetings in person, one at the courthouse and at both depositions regarding disclosure, including the court requiring the parties to submit a list of the providers they intend to seek HIPAA records from, where petitioner notably failed to mention Planned Parenthood, Mission Viejo telemed providers, or other providers. Which we knew that Planned Parenthood in California was one of her HCG tests. So we already knew that that was there. So that would have needed to be at least one of the HIPAA release records to be sent to them, because that's one we already knew about. But she didn't give the information for us to do that. Petitioner continues to claim there are records in her exhausting attempts to explain away why no medical evidence supporting her fictional pregnancy exists. Number 15. Respondent is entitled to his reasonable attorney's fees in cost incurred in this entire action, including filing this motion to compel. Petitioner's commitment to crafting a trail of medical evidence that cannot be verified, an anonymous appointment, a photo of a miscarried fetus that somehow disappeared when you get a new phone, a confirmation of an appointment with a doctor you never go to, etc., is astounding. The petitioner keeps weaving this insane web, has only caused respondent to incur more fees to show what he has always known to be true, that petitioner is a fraud who concocts fictitious pregnancies as a ruse to force men into dating her. Due to the significant efforts he has undertaken, respondent is entitled to his reasonable attorney's fees and costs pursuant to AR's S-25-324, which I think he could get. I think he's rightfully owed these. She has businesses, which I don't know if they're in her name. They might be in her parents' name. She has Airbnbs or real estate. I don't know if she has an apartment or a house or a condo or whatever she lives in, but they could put liens on those, or she could have to sell those in order to pay her settlements or her loss of this case. She's got stuff that she could pay this with, or she may have her mommy and daddy pay it, but and maybe after that they'll be like, okay, enough is enough. Wherefore, respondent respectfully requests the court: A, order petitioner to obtain the California paternity file from 2014, where she was first accused of faking a pregnancy, and disclose the same. B, order petitioner to obtain the records, if they exist, from Planned Parenthood Mission Viejo Health Center. Said records should come from the provider in light of the history of doctoring records. C, order petitioner to provide the name of the telehealth doctor who she claims told her that she did not need to seek medical care or hospitalization after allegedly delivering 2 stillbirth fetuses prior to the October and November court hearings. Yeah, and your belly doesn't continue growing when the babies aren't growing. So that's another thing. And you'd become really, really sick and ill, and you could die if you kept stillbirth babies in there longer than they actually needed to. D, order petitioner to produce the images, confidential if they exist, of the 2 stillbirth fetuses she allegedly delivered and shared with the telehealth provider, her sister, and her mom. E, award respondent his reasonable attorney fees and cost incurring in filing this motion to compel consistent with ARS 25-324 F, order such further relief as the court deems just. Respectfully submitted on the 11th day of March. Greg Woodnick and Miss Isabel. Alright, here we have Exhibit 1. This was sent on February 23rd. This was sent to Dr. McCool, which I hear he's an actually really cool guy, and he's great at prenatal services from people that have talked about having him as a doctor. It says, regarding the Owens v. Echard case, dear provider, attached, please find an executed HIPAA release regarding a potential patient of yours, Laura Owens, date of birth, who also may use the alias blank with the same date of birth. This HIPAA complaint release was executed by Miss Blank in front of Maricopa County Superior Court Judge Matt on February 21st, 2024 for use in the case number blank. As evidenced by her signature, you have the authority to release Miss Owens' records from August 2020 to present date directly to our office. The court will also be issuing a minute entry confirming your authority to release records regarding the same. Please promptly provide any and all records from the time period of any treatment, services, and communication provided to or with Miss Owens. This is meant to be comprehensive. Please note that this cause does involve fraud allegations against one of the parties, including medical records, doctoring, and manipulation. As such, please assure your custodian of records not only provides the full file, but that if there are records that were not produced by your office, e.g. submitted by a party through an online portal, that they be clearly identified as such, including the submission date, so that they are not misconstrued as records prepared by your office. Inversely, if your records search confirms no records exist, please have your custodian of records provide a basic affidavit indicating, I cannot read once again, 1, that they are the custodian of medical records for the facility. 2, a comprehensive record search was conducted. 3, no records matching Laura Owens or blank with the date of birth being blank were identified. We will be forwarding you the minute entry from the court confirming your authority under separate cover. For now, and because time is of the essence, we are asking that you expedite production of the requested data or confirm the absence of information and provide the same directly to our office. We appreciate your prompt attention to this matter. We'll of course pay for copies upon presentation of invoices. Very truly yours, Greg Woodnick, and he CC'd Corey Keith, Esquire. Here is Exhibit 2, Owens v. Echard on February 27, 2024. Comprehensive legal notice of intent to sue for breaches of contractual and fiduciary duties. Dear Mr. Echard, so this is the email that she sent him to extort money from him. I write to you with a matter of utmost legal gravity and urgency pursuant to the breaches of the contractual obligation, fiduciary duties, negligence, fraudulent misrepresentations, professional misconduct as verified by the Arizona Department of Real Estate. Your failure to fulfill your professional obligations, specifically in relation to the properties at, has necessitated this action. No, it hasn't, because the real estate board and his office have already dealt with this. But, okay. Number 1, specification of damages. The total compensatory damages sought is $1,368,936.80. I think I did not read that properly, but basically $1.4 million. Is meticulously calculated based on the current market values of the aforementioned properties as of February 27, 2024, amounting to $1.2 million. This valuation is derived from reputable real estate valuation services, including Redfin, to ensure accuracy and fairness in compensation for the loss of the opportunity and financial detriment caused by your actions. Additionally, $124,448.80 is sought for emotional distress. Ma'am, if you do not get off your high horse, I will kick you off of it. Quantified in consideration of the psychological impact and distress directly attributable to your professional negligence and the subsequent Arizona Department of Real Estate findings. You are the cause of your own psychological problems. And you owe him way more than that for the emotional and psychological distress and defamation and fraud and everything that you've committed on Mr. Echard. So go somewhere else with your numbers and valuations. Number 2, legal foundation and the ADRE findings. The ADRE's determination that your failure to submit an offer constituted a violation of Article 2 Professional Conduct R428-1104, specifically regarding the expeditedness for performance required by a license holder, solidifies the legal basis of my claims. This finding is pivotal, not merely as an administrative abomination, but as a substantive evidence of your failure to uphold the duties owed to me, thereby strengthening my legal stance on the breaches of your contractual and fiduciary duties. He complied with ethical duties. He crossed those, and he did a no-no that landed him in this crazy case, but no, he tried to get you with somebody else basically that same day or that next day, so that if you actually wanted it, you could have had it, but you didn't want a different real estate agent. You had your eyes set on Clayton. The precedential value of similar legal disputes, notably Stewart v. Sterling, as adjudicated by the Arizona Court of Appeals, serves as a pertinent legal analog, illustrating the judiciary's stance on such professional breach within our jurisdiction. It is imperative to acknowledge that the legal principles espoused in these precedents underscore and the seriousness with which the courts regard such breaches and the consequent liabilities thereof. 3. Stipulated conditions for resolution. In lieu of immediate litigation, I propose an alternative resolution contingent upon your stipulation to dismiss case Owen v. Echard forthwith, and to mutually agree to forbear from any future legal actions against each other for any claims. That line is taken directly out of her relationship dating contract. This proposition is tendered in spirit of amicable dispute resolution and to mitigate further legal entanglements. You're the one who got involved in this entanglement. Requirement of immediate compliance. Your response to this legal notice is mandated by no later than February 29, 2024, by the close of business. Absent a satisfactory response, I am fully prepared to initiate legal proceedings to seek redress and restitution for the aforementioned breaches. Sincerely, Laura Owens. She's not wishing Clayton all the best now. She's changed it. And this part up here, the utmost legal gravity and urgency, like she uses that line in her cease and desist to like the Reddit people. Like, she just copy and paste. Like, she just is the queen of contracts. This is from Greg Whitnick. And it says, "It is my understanding that you represented Owens in a paternity claim involving blank in 2014. That matter involved allegations of a fabricated pregnancy with altered medical records. It is our understanding that the feigned pregnancy was perceived as a ploy for your client to coerce into a relationship." Same dog, same tricks. "Since that case resolved in California, 3 additional men have claimed that they were victims of a pregnancy ruse by Owens. I represented Clayton Echard, the pending matter in Arizona. Laura is represented by my friend and colleague, Corey Keith," which he copied him on this. He also copied his Isabel and Corey's Isabel on this. "We are requesting cooperation for access to California's paternity file with Miss Owens, neglecting to mention the litigation and prior discovery delays and upcoming trial. We need this process expedited. I am asking you to connect with Corey Keith to coordinate production and disclose of the California court file. Of course, we are not requesting privileged information, only the public file from your court. Our efforts here are about obtaining the otherwise limited access California file without the need to file a motion to compel Ms. Owens' compliance with disclosure of prior matters. Arizona rule requires that parties attempted to resolve discovery disputes before bringing them to the court. This is that the effort, and I certainly understand that your response may simply be that you no longer represented Ms. Owens. I need to ask as a precondition to asking the court for relief. Greg Whitnick." So he is showing that he did ask for these records prior to bringing it to the courts. And he did this on March 4th. This is an email sent on Friday, March 8th. "Corey, as it has now been a week since we deposed Laura, and we have yet to receive any disclosure from you. Number 1, Laura claimed that she had an appointment with the telemed providers about her alleged miscarriage. She testified she would be providing us with the provider names, and we have not received the same. This times our consulting experts who are already limited to records they are reviewing in the light of Laura claiming that the sonograms she sent to the media and Clayton are not hers. The fact that she does not know the date of the alleged miscarriage is incredible," which means unbelievable, "but could be supported if she provides records from the appointment she claimed she had immediately had after the alleged miscarriage, including the photos she testified she shared with the provider of the 2 hand-sized fetuses she delivered. Laura has health insurance, so the provider should be a phone call away for confirmation. If she paid by credit card, she could just look at the statement and give us the vendor name so we can issue a subpoena. There is no excuse for the delay other than more of the same. Doctors claim that they say she was not their patient and records never existed. As you saw in the supplemental discovery, more providers she claimed she was using have no records. We anticipate Planned Parenthood confirming the same. Number 2, Laura lied when she said there was no other litigation she was involved in. The situation with blank appears to be paternity matter in San Francisco. Those files are not public but can be accessed by the parties. Her California attorney did not respond to my email, and neither did you. I am happy to ask blank to cooperate with the release of records. I trust Laura realizes he will confirm yet another pregnancy con from 2014. That was eerily similar to victim number 4. At least we believe him to be the 4th, Clayton. Number 3, we need the alleged fetus photos. Laura said she sent them to both Sarah and the telemed provider, also her mother. Oh, her sister's name is Sarah. Oh. Man, I'll be giving people a bad name. If she provides the provider name number 1 above, I am sure we will find them there in their records. We should not be fishing for these, as Laura should provide the same after she testified under oath to having been seen by these providers and volunteered the information regarding the photo she took and dispatched. She has been on an iPhone for all 4 men, so there will be accessible iCloud backup. It will be easy for Brian Newmaster, tech forensic expert. Okay, Brian Newmaster is he's a goat, in my opinion. He is the one, if you paid attention to the Johnny Depp and Amber Heard scandal, that did the photo on top of each other that showed that the pictures that Amber was saying were 2 different photos were not 2 different photos. That were exact same photo taken down to the minute, and when placed on top of each other, they're exactly the same. So, and if you haven't followed that case, go to that playlist. I did a deep dive on that one as well. So, Newmeister is going to be able to call out the fraud. Most definitely. Is the Newmeister being brought in on this case is not good for Owens. So he wants to see her images from September/October that were sent to the sister and the telemed provider. You did not want her committing to the process at the deposition, which I understand, but Laura needs to cooperate or we are going to seek court intervention. Our medical expert needs to see the images so that they can cross-reference them to the alleged timeline of the pregnancy that never was. I think our discussion about disclosure at both depositions and our chat before the last hearing with, whatever that means, Judge Matta covers our Rule 9 obligation. If you disagree, let me know and we can talk Monday afternoon anytime after 2 p.m. Laura can anticipate our motion to compel. Last, it should go without saying that I am sure you did not know about the pregnancy fraud case in California or that Laura tampered with the exhibits that you used as evidence in Clayton's deposition. I think Bonnie Platter realized that the records were fake and that this is why they tagged out. Perhaps Lexi also realized the same. Greg Woodnick. This is from Greg Woodnick to Corey Keith, and says, Corey, at the status conference on February 21st, 2024, you told Judge Matta that Laura had not lied in prior or current proceedings. I trust you have realized that may have been an inaccurate statement in the wake of her deposition last Friday, and that you may need to amend your statement. Number 1, you were copied with the email to Planned Parenthood Mission Viejo, as I am sure you saw. Staff confirmed that they do not offer anonymous appointments, and if Laura did go there, which it is highly doubtful given the tidal wave of providers who have denied ever seeing her, she would have access to the patient portal and should have no difficulty obtaining the original, not tampered with, sonogram. Number 2, I am forwarding you the records we received from Barrow. You will note on page 45, Laura tells her neurologist during an appointment on November 29, 2023, that her OBGYN thinks it was a chromosome thing that caused her to miscarry, and she passed 2 things that look like fetuses. I'm eager to see those OBGYN records. A chromosome thing. I'm not even going to go there for that one. Number 3, per your client's testimony, please immediately disclose A, the names of telepath telehealth providers she spoke to on August when she was spotting, per her testimony, and in September/October on the day that she allegedly miscarried, 2 things that look like fetuses. B, the abortion pill provider who allegedly is the only individual who told her she was pregnant with twins and that they were a boy and a girl based on what we know now is a doctored sonogram. I was not aware that the abortion pill providers were able to use ultrasounds to see the genders at 8 to 9 weeks. I Googled it. Medical science is not aware of it either. No, because you know what else? They can do a blood test, but that's usually later down the line still. You still can have that blood test be performed to find out the gender sooner than the 20-week mark that a lot of people find out with the ultrasound, because still before 20 weeks they still cannot tell via ultrasound. But Laura is a miracle case. 4, also why can I not say per today? My goodness. Your client's testimony. She was even seen in August at Honor Health. They too have no records of seeing her. See attached. And add blank to the list of victims. I am sure you did not know this because unlike the overt lies plaguing the case, Laura lied to you by omission and never told you about the litigation in California that involved nearly identical allegations of a fake/doctored ultrasounds. Here's our theory of the case. Laura Owens is a serial pregnancy faker and a prolific forger of medical documents, apparently for at least 10 years. Her modus operandi is to force relationships with men who do not want to be with her. Zaddy Gregg signing off there. Alright, here we have another exhibit, and it's an email from Woodnick to Corey Keith. Corey, I am confirming receipt of the disclosure we received from your office late Friday night. I'd like to quickly point out that the section with the advisory regarding medical records includes alleged records that are already part of the public domain published by your client herself. My understanding is that not only did Laura post them, but she also emailed them to various journalists, including Reality Steve and Dave Neal. She even refers to some of them in her publications, which she appears to be revising to fit a new alleged miscarriage timeline. Yours presented to Judge Matta last week. I trust she is aware that the original versions have been preserved. I am assuming you are not aware of the extent she has put her records out in the media sphere of her new tactic of revising history, parts of her arts and crafts. I added that. Of course, we intend to honor Judge Matta's directives regarding medical records, but in anticipation of her alleging there is a leak regarding what you just provided, I am advising you in writing of the history and that the majority of records, quote unquote, provided were the very same Laura published online. Last, I was hoping that your disclosure from Friday would have been something closer to complying with the overdue RFP and Rule 49. This puts the financial burden of discovery on Clayton, but is completely not surprising in the light of the history here. We will disclose the records we receive in the response to the HIPAA request. I trust you saw that the first vendor denied any records even existed. We will see you Friday, Greg. And then would appreciate if you would share the attached with Clayton. Regards, Owens. This is also from Owens, stating on February 27th, Corey, your client emailed me directly tonight below. I'm sure you did not approve or even know about this as it was so woefully inappropriate. Of course, I did not respond. Number 2, this will be an exhibit at trial. You can also expect my client may release this to the media as exposing Laura's overt and nonsensical extortion does the world good, and nothing contained in her notice is private information. 3, I have more witnesses stepping forward regarding your client pattern of faking pregnancies and using this disturbing narrative to somehow extort relationships. Number 4, I trust you already saw that 3 of the providers now, so just a day later, there was 1, now we have 3, your client claimed were providing services have indicated they have no medical records for her in their system. I look forward to seeing you both on Friday. And this is also from Owens, says, Greg, I'm contacting you directly rather than going through Corey, as this is related to a civil matter. And that's where this, I would appreciate if you would share the attached with Clayton. Regards. At least she's changed from all the best. All right, this is an email from Corey Keith to Woodnick. Good afternoon. To ensure an exhaustive list, my client asks that I also communicate the following providers for your records: MomDoc and Banner Health. Well, we knew about Banner Health already. If these are already covered in your below list of providers, please disregard. Let me know if you need any additional information. Warmest regards. So he changed law groups, so his ending is not that logo anymore, and now it's this one. And then it says, please include my paralegal and on all communications, and then the confidentiality. His paralegal went with him, I guess, to the new firm. And then this says, good afternoon. Per the court's request, the providers will be requesting records from the VIA HIPAA release signed in court today on February 21st, 2024 by Ms. Owens, and subject to additional providers listed by Mr. Keith. And so far we have Dr. Higley, Dr. McCool, nurse practitioner Tamara Lister, Dr. John Jones, One Medical, Honor Health Scottsdale, Family Planning Associates, Any Lab Test Now, which we already knew about, Choice DNA, Arc Point Labs, Planned Parenthood California, Southwest Medical Imaging, which is where that sonogram was doctored from, Barrow Neurological Institute, and Dr. Zyman. Thank you. And Isabel with Corey Keith signed it. Isabel Rainey is Woodnick's Isabel. Isabel Sissel is Keith's Isabel. And so that is what we have there. This is a good faith consultation certificate in conference with Rule 9C, Arizona Rules of Family Law Procedure. Counsel undersigned hereby certifies that Respondent Clayton Echard satisfied his Rule 9C obligation when he had a private in-person conversation regarding petitioner's outstanding disclosures with petitioner's counsel Corey Keith around 10:30 a.m. on February 2nd, 2024, and on prior to the status conference on February 21st, 2024. Respondent's counsel sent numerous emails to petitioner's counsel. See the March 4th, 2024 email regarding the same, and specifically requested a meet and confer on March 8th, 2024, which is as of the date of signing has not been responded to. Greg Woodnick. All right, this is the press release. Many of you have probably seen by now. This was released on March 7th, and it is from Clayton Echard and his counsel, obviously. And it says, in response to media inquiries, Mr. Echard has authorized the release of this statement. Echard vehemently denies ever having intercourse with Owens and her correspondence, part of the 500 pieces of communication that predicated the Maricopa County Superior Court granting an injunction against harassment against Owens, confirms the same. Echard immediately realized he did not want a relationship shortly after a consensual non-intercourse encounter with Owens. He promptly attempted to distance himself from Owens both personally and professionally. 5 days after their non-intercourse encounter, Owens started suggesting she may be pregnant. 6 days after she claimed she had confirmed she was pregnant. Within weeks, she claimed she was carrying twins, male and female. Impossible. Mr. Echard was beyond incredulous of the pregnancy because of the performance of fellatio does not cause pregnancy. Fellatio meaning oral. Her rapidly evolving yarn did not comport with obstetric timelines. Her claim of twins with assigned genders less than 8 weeks into the pregnancy did not comport with medical science. At least not yet. The consequence of Clayton ignoring communication with Owens, refusing to enter into her dating contract, and demands to meet with him privately to discuss a parenting plan for pretend twins, was that she vindictively contacted The Sun, Page 6, and New York Post. The Sun first reported the story without knowledge that Owens has been accused of fabricating pregnancies and doctoring medical evidence as a means to extort relationships several times dating back 10 years. The byproduct of the media coverage Owens initiated was the unification of some prior victims who have shared their experiences. The commonalities including medical images hijacked and photoshopped from the recesses of the internet and confound attempts by Owens to get them to agree to date her in exchange for her discontinuing sham pregnancies. Clayton, confident he was being extorted as he did not have intercourse with Owens, demanded she produce evidence/disclosure. To avoid the anticipated claims about placing the imaginary twins up for pretend adoption, Clayton reached out to the Arizona's Punitive Fathers Registry, which, if somebody tries to put them up for adoption or in foster care or whatever, his name is going to pop up that, hey, he's the dad, and he's not giving permission for this. Boxed into her fable after being captured on camera jumping horses during her high-risk pregnancy and then on court video weeks later with what appeared to be a fake moon bump claiming she was 24 weeks pregnant by Clayton, this bizarre fishtail came to a head. In December of 2023, Owens cryptically claimed she was no longer pregnant and wanted to dismiss the action and avoid sharing any disclosures regarding her malignant faux pregnancy. After failing to appear at her deposition, the court set a status hearing. At this status hearing, the world would learn that she claimed she miscarried before her November testimony. Owens was deposed on March 1st, 2024. As the matter is being prepared for trial, and these are both public persons, Clayton provides the following statements. Private medical records will not be shared publicly. However, some quote-unquote medical records are already part of the public domain, as Owens sent what she claimed were her medical records to the media and shared the same on social media platforms. Yeah, things that are not medical records, not medical evidence of anything. Owens since denied that a sonogram received from her and posted by her to the internet is her medical record. But she also claimed that Greg Gillespie hacked her and did that. She never said that, is what she also said. Again, Owens emailed the sonogram to multiple journalists in addition to Mr. Echard. Number 3, records from Southwest Medical Imaging, Smile, were tampered with by Owens. Owens admitted that she altered medical records and falsely attributed them to Smile. Southwest Medical Imaging did not image Owens for pregnancy, and their legal department is fully aware of this arts and crafts forgery that she circulated under their trademark. Use of this image was a fraud on the court to the extent the records were used in the collateral proceedings. Number 4. Despite Owens testifying in the collateral proceedings to having attended appointments with various high-risk pregnancy and obstetrics providers, there will be no records confirming because no obstetric care was ever sought. Number 5. Claims of a doctor confirming the pregnancy are patently false. A telemed video appointment with a neurologist is not pregnancy confirmation. No, there would have been none of that. And if she has something that states that, it's because she told the doctor there was a positive pregnancy test or that she was pregnant. She would have self-reported it because the doctor cannot perform any test via video. Number 6. The press has reached out regarding the identity of other individuals, in addition to the 2 who have had public cases involving similar allegations, who were victims of pregnancy fabrication. Clayton appreciates that the job of journalist and the will of the lay army of investigators captivated by this saga is not something he can control. He requests that journalists and investigators, professional and amateur, realize that Clayton and Owens, a self-help podcaster and TEDx speaker, are public people. Others who have been impacted by her serial pregnancy fraud may not be public persons and understandably may not want their private matters discussed. Number 7, Clayton asks the public to refrain from any behavior that Owens could claim is harassing or bullying. So he is not inciting violence. He is not telling people to go out and do anything to her. Nothing. Just nothing her. Clayton trusts the legal process, and is appreciative of his family and community, especially Bachelor Nation, who have continued to offer support. Yes, we support Clayton. March 11th. Greg Woodnick files the motion to compel. In this motion, Woodnick states that Owens claims to have passed 2 fetal sacs and has sent the picture to her sister and spoke to telehealth sometime in September or October. However, no evidence has been shared by Owens. 12. Keith submits a motion to withdraw as Owens' attorney with client's consent, making him next in the ongoing list of attorneys that refuse to further represent her. Also, the Sun retracts their March 7th article. On March 25th, Woodnick files a motion for joint hearing pursuant to Rule 5. This motion seeks to have the court rule if Owens' protective order against Echard can be dismissed due to being founded on both implicit and explicit fraud. The motion seeks for the judge to conduct a joint hearing and order relief to Clayton as the court deems just. March 26, Maricopa County Family Court docket shows that Owens has retained new counsel after her former lawyer, Keith, withdrew, and her new lawyer is now Mr. David Gingras. Here is the Sun's article that disappeared off the internet. Fraud bombshell. Bachelor Clayton Echard's ex-filing has admitted to fraud in foregoing pregnancy records after paternity test scandal. This woman was supposed to give birth in February. This was published on March 7th. Now it says, Clayton Echard from The Bachelor has won the battle against his ex, filing who claimed he got her pregnant. Clayton, 30, was accused of fathering the woman's unborn twins in 2023. Clayton has not won. Like in the court yet. As far as we know that Clayton was telling the truth and Owens was lying. Public opinion, sure. But a judge has not put the stamp of approval and said, yep, Owens, you lose. You're a liar and a fraud, and you need to go to jail. Which the judge won't say that, but she should. So the article says, the anonymous woman who claims she had a one-night stand with Clayton that allegedly led to her becoming pregnant. On August 1st, she filed a lawsuit in Arizona family court demanding he take a paternity test after he didn't believe he was the father of her twins. He actively fought against the accusations and denied ever sleeping with the woman. In December, the woman said she was no longer pregnant, but no more details were released. On Thursday, Reality Steve posted a statement on X, formerly known as Twitter, from Clayton that stated she was never pregnant. The statement claims that the woman admitted to altering medical records that claim she was pregnant. The statement also claims that claims of a doctor confirming the pregnancy are patently false. A telemed video appointment with a neurology is not pregnancy confirmation. It also stated that there would be no proof of a high-risk pregnancy because no obstetric care was ever sought, which we just read in the statement. Fans have his back. Fans on social media had a lot to say about Clayton's recent statement and new information. One wrote, I hope she gets jail time for this. Wow, good for Clayton. Now time to sue her for distress and harassment, added another. A third said she deserves jail time and to pay all of Clayton's legal fees. And I agree with all of those statements. Some may be fans of The Bachelor. Some may be fans of Clayton. I mean, as an individual person, I like that he's honest. Would I say that I'm like a fan? Not necessarily, because I don't like the word with the fans attached to it with public people, because you cannot be a fan of someone but still want there to be justice against them. And just because you want justice for a person who is telling the truth and somebody's trying to rake them through the coals doesn't mean that you're like a fan and stuff like that. Like, no matter, like, a lot of people, it makes fans seem like, oh, Clayton's fans, no matter whether he was actually the father of twins or wasn't, the fans would have supported him whether it was true or not. And I don't think that's the truth. I think all of us are fans because we see how honest he is and that something is unjust here and it needs to be made right. Continuing with the article, it says, good for Clayton. Now I hope he sues her and she is punished for everything she has put him through, commented a fan. A fifth wrote, I hope Clayton can finally move on from this travesty. He will. He's not going to be as trusting, and I hope he is a little more selective with people that he chooses to enact and engage in certain things with. Maybe be a little bit more picky. In January, before the confirmation, Clayton's ex-fling claimed she's no longer pregnant. The U.S. Sun can exclusively reveal. 4 months after he was accused of fathering the woman's unborn twins, she made a bombshell claim in the Arizona court filing. On December 28th, the former Bachelor's ex-fling filed a motion to dismiss with prejudice her petition that was initially filed in August to establish paternity, legal decision-making, parenting time, and child support. With prejudice means the case can be dismissed permanently and not be brought back to the court. Yeah, that wasn't happening. According to the court docs exclusively obtained by the U.S. Sun, the petitioner claimed she was no longer pregnant. The 33-year-old podcaster, she was 23 when she started all of this crazy nonsense. Like, for 10 years, she was 23 when she first started all this nonsense, so far that we know. I mean, maybe she pulled this same junk on people in high school, too. Who knows? She's a podcast host from Scottsdale, Arizona, noted in the docs. Petitioner acknowledges that she is no longer pregnant with respondent's child/children, meaning there is no paternity to establish. Oh, yeah, let's just wash our hands. Like, nothing to see here now. Like, no babies. Like, we're done, right? No. You're going to be called out, woman. She continued, there is nothing left for this court to adjudicate, and this case should be dismissed. She describes her current state as not now pregnant. She initially said she was expecting to give birth with twins on the 14th. Well, oh my gosh, you're just not pregnant anymore. So, hey, we don't need to investigate my lies anymore. Like, go away. There was no explanation given as to what had happened during the supposed pregnancy. But in an earlier thing, apparently she alleged that it was maybe a chromosome thing that caused the miscarriage. Also, you want to find out why you had a miscarriage. Why you gave birth to still babies. Why they were not able to go to full term. In my situation, I learned that I had an incompetent cervix. And so that meant in order for me to carry my children that I now have to full term and have children, that I needed to have a cerclage where they go in and they sew the cervix shut for most of the pregnancy so that it would have it would just be enclosed better, and they would stay in there, be more strengthened and not weakened. And so that is what I did with my next two kids, is I had that done with them. And sadly, in that situation, the only way to find out that you have an incompetent cervix is to actually go through losing a child like I did. So as a person who possibly wants to be pregnant and have kids, you would definitely want to know what the explanation was. Is it something with you? Is it something with him? Was there something wrong with the baby? Because you're going to want to fix that so that the next time you get pregnant, it doesn't go like this. But obviously in fake pregnancies, you don't need any of that information because none of it happened. So why do you need to request information? The reality star's ex, she is not an ex. Like, don't refer to her as an ex. Is still requesting she be awarded attorney's fees and costs and a virtual evidentiary hearing to hash out things between her and Clayton through the court. The U.S. Sun has reached out to the petitioner for comment, and she probably did not respond. So this article has disappeared from the internet, but now you know what it says. All right, just a couple more things to go over before we get to the deposition, the fun part. And it says, motion for joint hearing pursuant to Rule 5A. This was sent to Judge Duty and Judge Mata. Defendant responded, Clayton Echard, by and through counsel, undersigned pursuant to Rule 5, Arizona Rules of Family Law and Procedure, hereby file this motion for a joint hearing as, and for his motion, defendant/respondent states as followed. Number 1, contemporaneous with this filing, defendant respondent has filed his motion for relief from judgment based on fraud, seeking redress in the underlying order of protection. Cause of action, blah, Exhibit 1. Number 2, an identical matter regarding similar concerns of a fraudulent conduct involving fabricating pregnancies and doctored medical evidence by petitioner/plaintiff is currently pending adjudication before Judge Mata in the case, blah. The file trial setting for June 10th, 2024. Number 3, Rule 5A4, Arizona Rules of Family Law and Procedure provides that although the court may not consolidate a case involving an order of protection with a family law case, it may conduct a joint hearing. Number 4, Defendant/respondent maintains the proper remedy is for judge duty to immediately dismiss the order of protection obtained by fraud as set forth in the contemporaneous motion for relief from judgment based on fraud. Number 5, in the interest of judicial economy, should the order of protection not be dismissed based on defendant's motion for relief from judgment based on fraud, Judge Matta's division should conduct a joint hearing. Yeah, she should not have this order of protection. And this order of protection that was obtained fraudulently needs to be wiped off of Echard's record. Like, he shouldn't have that on his record, because it shows that he had one on him at a point in his life. And nope, he doesn't need that on his record. Take it off. Wherefore, respondent defendant respectfully requests the court A, conduct a joint hearing pursuant to Rule 5A4 if the protective order is not dismissed based on fraud. B, order such further relief as the court deems just. And this was signed by Woodnick, and a copy was sent to the judges along with others who needed to be served or given a copy of the filing. Now, this is what the order of protection was saying. And so it says, one party is pregnant by the other. Nope. Romantic or sexual relationship, past or present. Okay, she can still check that one because they did fool around. Number 2, if checked, defendant and I have a pending action involving maternity, paternity, annulment, legal separation, dissolution, custody, parenting time, or support in Maricopa County, which they do. And they listed the case number. And then tell the judge what happened. So this is kind of like what we viewed on Clayton's injunction against harassment, where he filled in like the dates and the story about why he needed that. This is her version for her order of protection that she wanted. And it says 6/1/2023. Clayton has sent threatening messages since discovering I was pregnant, such as, I legitimately hate you right now. Okay, that's not a threat. My hatred will only grow if you decide to put me through all of this. Once again, not a threat. My animosity would last for a lifetime, and that's not something either one of us wants to subject ourselves to. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway. Ever. My hate towards you and you only. If you decide to not take Plan B, and in the wild event that you are pregnant, I would hate you even more. Yes, he would. That's not threatening. I mean, threatening to hate you? No, you've already brought that on yourself. And he can say all this because he knows you're not pregnant. On September 21st, 2023, Clayton Echard was the Bachelor and has many die-hard loyal fans. No. Does he have fans from The Bachelor? Yes. Are most of the people that are interested in this case, because you're cray-cray, are they die-hard fans? No. No, not at all. That's what I was talking about earlier when I was talking about fans. I don't like that narrative. He and I are involved in a very public paternity case that is being covered by every major media outlet. Clayton posted to a story to his 270,000 followers to look me up, which they have, and I have been sent threatening and harassing messages by his followers. I explained this to him and asked him to take down the post, which he did not. By posting personal and sensitive information about me publicly and without my consent, he has made me feel humiliated and embarrassed. No, you have done that to yourself. Also 9/21/2023, Scottsdale officer Vince Johnson called Clayton to explain that what he was doing was harassment in and of itself, coupled with the fact that he was inciting his followers to harass me as well. Despite this call, Clayton still did not take down the post. 10/5. Between September 22nd and 10/5, Clayton has posed as several users on Reddit, including Silly Goose Tits, Gossip Goose Tits, Sand Between Her Toes, and others. How does she know this? How does she know that is Clayton? You have no proof of these allegations. You better come with proof if you're saying this stuff. Because I would be dismissing off of that part. I wouldn't even be considering that part because you have no proof that is actually him. He has posted private and confidential information, including facts about my medical history. This is known only to him because our paternity case. So maybe you are Gossip Goose Tits and Silly Goose Tits and Sand Between Her Toes. If you two are the only ones that knew. Because I don't see Clayton wasting his time with this nonsense. You, on the other hand, are known for arts and crafts. This is why it is 100% traceable back to him. No, it's not. It could be you. He has also been writing defamatory and very hurtful things about me, including comments about how I have gained weight. I am pregnant. How am I not attractive? How my photos are so poorly edited that it's laughable. Yeah, your sonogram stuff is laughable. I am bad at my job, a self-help podcaster. Yeah, because you can't even help yourself. How are you supposed to give other people help? Nobody take her advice. And how my prior abusive relationship, which inspired my TED Talk, never happened, despite the mountains of evidence. Once again, nobody has ever seen this mountain that you claim that existed. It's not on the maps anywhere. He is doing everything in his power to ruin and hurt my reputation. As a result of what he has posted, I have gotten harassing messages that have told me to harm myself as a result of becoming pregnant with his twins. I am getting other threatening messages as well. And all of this attention from the general public that he has incited is very much unwanted. No, it's not, because you're the one that put it out there. As a result of this public shaming, he has caused me extreme psychological harm and disrupted my peace. You disrupted your own peace. You've been disrupting your own peace for 10 years now. So, give it up. I have asked Clayton to stop the harassment on Reddit and social media on many times, but he won't. I have reported his accounts and posts to Reddit, but he continues to write unacceptable and cruel things about me. You have no idea that that's him. He has multiple accounts now, and so even if one is blocked, he can create another one. You do that, and you would know that. As a result of him spreading false and damaging information under pseudonyms, you're the one with pseudonyms, trying to change your names and going by other people and trying to be anonymous but not anonymous. I feel demeaned, humiliated, and like my deepest sense of privacy has been invaded. Yeah, well, you did that to him. In addition, he has been in communication with my ex, who I have an order of protection against, and who he knows is dangerous. Nobody knows he's dangerous, because nobody knows what you're saying is true. We can't trust a word you say. And the man, your ex, can communicate with Echard. He can't communicate with you. Warning a person about you is not a violation. I have asked him to stop talking to him because it will put me in danger, but he continues to communicate with him. You're not in danger. You're in danger to yourself. October 6th. When combined, all of this has led me to feel extreme anxiety and fear for my safety. I have not left my house since September 28th because of this. That's a lie, because you went horse riding. But okay. The following person should also be on this order because defendant is a danger to them. Defendant should be ordered to stay away from these locations at all time, even when I am not present. Residence, work, business, school, and other. And then signed under penalty of perjury. No cyber harassment or cyberbullying under real name or pseudonyms. Defendant should be ordered to stay away from any animal that is owned, possessed, leased, kept, or held by me. Defendant or a minor child living in either household, which that's not a thing. She didn't check the firearms thing, so that's good. And so she's requesting relief. That is all the mumbo jumbo BS jargon she has created. Here we have the minute entry from Commissioner Duty. Prior to the commencement of today's proceedings, Plaintiffs Exhibit 1 through 18 and Defendants Exhibit 19 through 51 are marked for identification. Courtroom, 8:32 a.m. This is the time set for hearing on an order of protection issued on October 6th. Plaintiff blank is represented with the above named counsel. Defendant Echard is presents on his own behalf. A record of proceedings is made digitally in lieu of a court reporter. Owens and Echard were sworn. The court addressed previous motions filed by the plaintiff. 10:13 hearing concludes. Hearing order was filed. Later, let the court reflect. The court did not invoke the Brady order due to the fact that it is still undetermined if plaintiff is pregnant with defendant's child. Our parties representing themselves must keep the court updated with address changes, and then the form can be downloaded. Okay, so Halloween is several months away, but it will be here before we know it. I mean, we're almost in April. I don't know where time is gone. And this is the anonymous woman costume. You need your little sonogram, unbrushed wig or your own hair, a moon bump, some leggings, and a sports bra. This will all be included in your package. So, if you need a costume idea, here's how to win the most deranged costume of all time for this year. All right, now let's get to the good stuff. The deposition. All right, here is some of the transcript from the deposition. Skips around a little bit. So this was done on March 1st. So this is Owens' deposition. And the witness is this. And these are the exhibits. They are previously marked and supplied in a binder with exhibit tabs. Some of the exhibits not tabbed and therefore not defined in the index. We have the ultrasound. We have text messages. We have another ultrasound. We have a LinkedIn message. We have more text messages, a sonogram video, a sonogram still from the Southwest Medical Imaging place or Smile. We have twin boy gender ultrasound. We have text messages, more text messages, Scottsdale Police Department report, an email to Reality Steve on February 25th, a video with her dad, a video of her pregnant stomach, the email to Reality Steve, that was on Friday, October 13th, another email on October 6th, more emails, crying on Facebook video, surprise email, email to Arizona SPC, Colin Scanlon email, whoever he is, more emails. So let's jump in. We're going from page 4 to page 26 of the transcript. So name begins with a Z, but I forgot. We went over that Dr. in the list of providers email that Corey Keith sent. Question. She is your neurologist at Barrow? Uh-huh. Yes. So you also told me you are seeing the online provider, correct? Correct. When was the last time you saw the online provider? I haven't had a video visit with that person in maybe a year and a half or 2 years. What other providers have you seen? Let's just look at the last 24 months. In the past 24 months. I saw a doctor at, I don't recall. I saw a provider at, I think her name was Tamara, something with an L, and I think she may have been a nurse practitioner. She's also on that list of providers. I saw a doctor at blank at Planned Parenthood in Mission Viejo. You said, how long did you say? How long? You are doing great. So one of the questions I had ahead of me was, you have been to Planned Parenthood in the past 24 months? Yes. And the Planned Parenthood you have been to is the Planned Parenthood Mission Viejo, or whatever the branch is there? Yes. When was that? That was in July of last year. July of 23? 23, correct. You and I have no problems expanding the HIPAA release to include Planned Parenthood Mission Viejo for July 23. Nope. Have you seen any other providers at Planned Parenthood in Arizona? No. Just the one visit in the summer of 23 to the location in Mission Viejo. Yes. Any other medical providers in the last 24 months? Jumping to page 80 now. I'm going to show you Exhibit 9. Exhibit 9 is from Scottsdale Medical Labs. Have you been a patient at Scottsdale Medical Laboratory or Labs? Yes. This is an ultrasound dated July 7th, 2023. Yes. Is that your name on top of your birth date next to it? That is my name and birth date, yes. And this is the ultrasound that you received at Smile that was presented by Bonnie Slater in the prior proceedings, correct? Yes, it was. It was. But this was actually at Planned Parenthood. Okay. I want to make sure I clarify that. Let's start off with the basics. On Exhibit 9, this is your ultrasound. Yes. Did you go into a facility, a Smile facility, because it is earmarked Smile, to get this ultrasound? I did not. Where did you get this ultrasound? Planned Parenthood and Mission Viejo. So I don't know Mission Viejo well, but is what you're suggesting that Scottsdale Medical Imaging has a branch in Mission Viejo, California? No! I'm totally confused here. I will give you a chance here to explain how there is a Scottsdale Medical Imaging ultrasound that you claim came from Mission Viejo. This was the actually taken in Mission Viejo. This was not taken at Smile. Why does it say Smile on it? I did change the top of that from Planned Parenthood to Smile, because I didn't want him to contact the doctor. Lady, you can't do that. You cannot do that. I'm showing you real clearly base stamp 0183. It's an ultrasound image that you are admitting to having changed information on. Is that true? Just the top left, yes, the location. I'm going to ask the question again. Yes. Did you change data on what has been marked as Exhibit 9? Mr. Keith. She answered the question, Greg. Objection form. Other than changing the word smile on the exhibit, did you change anything? No. All right. I'm going to give you an opportunity now, because we are 3 years into this, a year into this case. Is this the only document you have altered? Yes. So every exhibit in the entire history of FAIN, of our position, which is feigned pregnancies, this is the only document that you are acknowledging have touched via arts and crafts, is 0183, marked today for today's deposition as Exhibit 9. Mr. Keith, objection form. And Greg, I'm going to ask you, let's keep it professional in these questions. Okay, calm down, Corey. Like, is saying these, yeah, okay, fake pregnancies, but how is that not being professional? That's what they believe. Calm down. Sit back down. Take a drink, take a breath. Yes, this is the only one. I would hope that the fact I'm admitting it, that would mean something. Well, it means that you lied in an exhibit. Like, you lied in the exhibit. You understand that. So this is where we go back to the issue of you being able to plead the fifth. You acknowledge that you had a medical document that you changed, and you are telling me right now that's the only one that you have to know about. Yes. What software did you use to change it? Adobe Acrobat. Where were you when you changed it? At my house. When did you change it? Whenever this was, because I didn't want him to contact Planned Parenthood. Okay, remembering she went anonymously to Planned Parenthood. So even if she would have had it on there, like, how is he going to contact anybody, because she went there anonymously and didn't use her name and things like that. So, like, even if she had left it that way, Clayton and her story wouldn't have been able to even figure it out, because it was all anonymous. So she wasn't worried about him calling Planned Parenthood. So, at what point were you going to tell my office or your own attorney that you doctored a medical record? As I said, it's my ultrasound. It is my ultrasound. Bonnie Platter subsequently withdrew from representing you. No, Bonnie did not. I just didn't re-up the retainer because it was $5,000 gone through in a week. You were aware that Miss Platter used this exhibit in your proceedings, right? Correct. It was my ultrasound. I want to show you Exhibit 10. I think we have a little technology action here. Miss Rainey? Miss Isabel? There's actually no audio on this, but I'm going to show it to you. Video is playing. Did you see Exhibit 10? Yes! That video dated September 5th, 2023. Yep. Is that yours? No, I never stated that was mine. I was asked that by Dave Neal. If you want to see that video, video is in part 1, along with a video of my daughter on the same exact day, when she was pregnant with my grandson, to show what a real and a fake one looks like. The Exhibit 10, which is a smile sonogram. What's the identifying information on there? Redacted. What's the other identifying information on there? GA, gestational age, equals 17 weeks, 0 days. So you admit that the sonogram in Exhibit 10 is not yours. Okay, yes, that's not mine. Okay. If I were to look at a sonogram of this alleged pregnancy, the only place that I would see that from, its original source, would be Mission Viejo Planned Parenthood. Wait, are you talking about the video, or I'm confused? And that's fair. Your testimony under Exhibit 10 is that ain't you. Exhibit 10 is that, yes, correct. How many sonograms have you had for this alleged pregnancy? 1. Oh my God. That just says it all right there too. High risk, 1 sonogram in 4 to 8 months. High risk. Oh my God. Like, this is why nobody believes you, because this is not believable stuff. You would not be able to put this in a pregnancy movie. They would be like, that is not accurate. That doesn't even make sense. Nobody would even believe or buy into this movie. Where was it at? Planned Parenthood Mission Viejo. So I'm going to ask my question again. If I were to want the original source of the sonogram, the only sonogram that you took in a 6 or 7 month pregnancy, I could only get it from the source at Mission Viejo Planned Parenthood. Yeah, and I did go anonymously. Oh. So if I issue a subpoena on them, because you are going to sign a consent when we bring this to Judge Matta's attention, they're not going to know it was you. That was there. I self-paid. I mean, I don't know. You have insurance, but you self-paid? Okay. Nobody's doing that. Nobody's paying out money they don't have to. Okay. So I'm going to give you an opportunity again, because you have got statements under oath that we are about to get to from the prior proceedings. You do not have to answer my questions. You can always plead the fifth. your testimony now is that the sonograms that I just presented to you are not yours, correct?
The one sonogram is mine.
And it came from Mission Viejo? But Mission Viejo is not going to have any idea it was you because you did it anonymously. But then you went back and you added your name on it? Objection form. Yeah, that's funny. You put your name on it, but you were there anonymously. Guess who would have to put that name on there? They'd type it into their little sonogram box. So it wouldn't have been anonymous. That is more arts and crafts, dude.
No, I didn't add my name to it. My name was on it. I changed the smile thing.
Your name was on it.
And I changed smile.
Hang on for a second. You just told me that you were anonymous at Planned Parenthood.
But I changed smile on there. I think I'm confused as to what you're asking.
No problem. I will slow it down. What we're asking is, if you are anonymous, how did they know to put your name on the sonogram? Oh, you're so stupid. Let's continue while she is continuing to get caught up in her own lies.
And can you just tell me what exhibit?
Just to be clear, for the record, I am talking about Exhibit 9.
Exhibit 9.
That's the one that you say that you changed and attributed to another medical provider located in Scottsdale, Arizona, correct?
Correct.
And that's SMILE, which is an acronym for Scottsdale Medical Imaging Labs or something like that, correct?
Correct. I have gone there before.
You are a patient of SMILE?
Correct.
So when I get the subpoena for the records release from SMILE, this isn't going to be there because they didn't do this test.
Correct.
Because you just put their name on the test.
Correct.
This test, according to you, was originated in California.
Correct.
And you went in there anonymously.
Correct. And I added my name in the facility name. Correct.
So we are changing your testimony. So it's not. You originally said you just changed and added the word SMILE. But now under oath, you are saying you added your name to it too, correct?
Correct.
And your date of birth?
Yeah, I changed the top. My date of birth, actually, I think they may have had my date of birth. They may have had my date of birth there. They may have had that.
Like, are you trying to convince yourself? Is that why you're saying it so many times?
If you were to get the record, they may have my date of birth because they did ask my age.
Okay, if somebody asks you your age, somebody says, hey, how old are you? And you say, my date of birth is this. No. Somebody says, how old are you? You say 33. That's what you would say, Laura. Not, here's my date of birth. Oh my God. Like, she can't keep anything straight. When you submitted records to a court, you understand that you were signing a verification with them and that there's an expectation of honesty.
Yes, don't believe this was ever submitted to court. All right. I'm not done with Exhibit 9 yet. Your testimony now that we have worked through it a little bit is this entire top section of Exhibit 9 is an ultrasound from Planned Parenthood in California where you appeared anonymously. You took that ultrasound and you added your name and a date and information to it. The date is correct. Okay. Where is the original of this? I just have that. I'm sure I would have it on my computer. Okay. What would you have on your computer? Like the image, my photos. How did Planned Parenthood California Mission Viejo give you this image? I asked them to send it to me. Via? Maybe. I actually just took a screen grab of it. No, it doesn't look like that. I don't recall. I'm not familiar with Mission Viejo Planned Parenthood. Do they do like a medical records portal? No, they did not. Did you walk out of Planned Parenthood with this? With what? Whatever this image is that you doctored, did you walk out with it? Well, I didn't. Are you referring to doctoring in the terms of the top? Yes. Okay, I didn't alter the ultrasound image, and this is even reviewed by another doctor independently. We can debate that. But this particular image, how did you get it? I thought I had taken a picture with my phone, but it doesn't look like it was taken with my phone, so I don't recall. So you may have, your position would be, you were in Planned Parenthood, you took a screenshot with your cell phone, and then you came back to Phoenix and you used Photoshop to change the caption. I used Adobe Acrobat to change the caption, yes. How would you get me the original of what this was before you messed with it? I can contact Planned Parenthood to see if from the day I was there, if there are any records from there. But if you went anonymous, how are they even going to know that you are the anonymous person that is needing the records? So they didn't know who you were. Like, oh my gosh, this makes my brain hurt. So, you would be willing to, for my office, sign not just a HIPAA release, but a special waiver that California may require because of their confidentiality laws with their Planned Parenthood and privacy, so that I could have the original information, right? I don't know what's rights. I don't know what rights I would be waiving in California. Well, you want Judge Mata to have the original records in front of her, correct? Judge Mata will see I was pregnant. I have other pregnancy records as well. This is not a debate. This, in particular, Exhibit 9, you have provided, and you have acknowledged. To Clayton, yes. To Clayton. I have got it too. It's right in front of me. You acknowledge you made changes to this document, correct? Correct. And you acknowledge that it is important that we know what the original was of this document to know what you changed. Correct? Because right now, I got to take your word that it's the original, right? Because there's no verification.
Correct. So you're going to work with my office to contact Mission Viejo and get the original source material from their database, wherever it is, so we can see what this image looked like before you, whatever you did to it. Can we agree to that?
Like I said, I went anonymous, but I'm happy to help you guys however I can.
Why did you go anonymous?
Because I didn't want people to know I'm pregnant at the time.
But Planned Parenthood is privileged. You have been there before.
I had been there before, but I didn't want anyone to find out because I wasn't in a relationship or anything. Oh my gosh, you silly goose.
You understand why people may think you may be lying about this Exhibit 9, right?
I do, yes.
Okay, let's move on. I'm going to move on and show you Exhibit 10.
Was 10 the video?
Yeah, you saw the video. The September 5th, 2023 video. That is the end of the deposition transcript that we have so far. Hopefully more of this will come out, because even though this took so long to get to this big ring of things, this circle they're running, to get to her admitting this thing, but she still admits that it is anonymous. But she's going to be able to call, and they're going to know who she was, even though she was anonymous. Duh. Doesn't that all make sense? Okay, guys, this is the end of our video. If you've stuck around this long, or you've made it to the end, it may have taken you the days or whatever to watch this whole entire video. It was a really, really long one, but we are caught up to present day, and we are going to be closing this out with: whoever is detected in a shameful fraud is ever after not believed, even if they speak truth. And that is why Owens is not believed in anything she says, because she is a shameful fraud. So you cannot believe anything that comes out of her mouth. But that is going to be it for me. Please like the video and subscribe so that you can get notifications of new videos. Next, we are going to be going down the path of other parties and doing a compare and contrast to other victims of Owens. So stay tuned for that. Bye.